Welcome back, folks. We're going to get into Chapter 10, looking at community sentences. This will cover probation, intermediate sanctions, and restorative justice. First question we have to ask ourselves is, what is probation? Probation is the most common method for dispensing correction treatment to convicted offenders. First, it gives offenders a second chance. It allows offenders to receive rehabilitative treatment, and it's a cost-effective alternative to incarceration, because incarceration is expensive. So probation, when we think about it, it's a criminal sentence entailing the conditional release of a convicted offender into the community under the supervision of the court, i.e. a probation officer, and it's subject to certain conditions for a specific time period. There's a history behind probation and community sentencing. The idea of community supervision began during the medieval times, based on judicial reprieve. This is the common law practice that allowed judges to suspend punishment so that convicted offenders could seek a pardon, gather new evidence, or demonstrate that they had reformed their behavior. John Augustus was very much involved in the creation of probation. He's credited with starting probation in America in 1841. He supervised a select group of offenders released by a judge, and ultimately had a high success rate of rehabilitation. In 1878, Massachusetts authorized appointment of a paid probation officer, and in 1925, the federal government established the probation system. So by 1878, when Massachusetts authorizes the appointment of a probation officer, we see that Augustus's ideas and work has actually been paying off. And in 1880, it was extended to other jurisdictions in Massachusetts, followed by Missouri in 1887 and Vermont in 1898. What's probation look like today? Well, about 2,000 probation agencies exist in the United States. Half are administrated by the state, half are administrated by county or municipals. Nearly 4 million are currently on probation. About 2 million become probationers each year. Males make up about 3/4 of probation populations, and more than half are white, non-Hispanic, and nearly 1/3 are African American. How do we award probation? Well, ultimately it's a contract between the offender and the court. Probation involves this type of contract. This contract outlines the rules of behavior that the probationer must comply with during the term of probationary period. Some of the rules or conditions or restrictions mandated by the court that must be obeyed, and if they are not obeyed, then the court can revoke a probation and then institute the fines and actions from the court that have been suspended because of probation. Revocation or an administrative act performed by the parole authority removes a person from parole. And by removing a person from parole or probation in response to a violation, that parolee or probationer has to go back in front of the court to receive the full punishment that has been suspended because of parole or probation. More than half of all probationers are directly sentenced to a term of probation. Many probationers are originally sentenced to a term of imprisonment and then awarded probation. This suspended sentence is a prison term that is delayed while the defendant serves a term of probation. If the offender completes the probation term without further trouble, the prison sentence is terminated. But in a split sentence, an offender is required to serve a jail sentence and then is released on probation. In the remainder of the cases, the imposition of a sentence is suspended and the case continued without a finding until further notice. Probation eligibility. Originally, it was designed for nonviolent offenders, but today even violent offenders may receive probation. This is a means of reducing the population in the overcrowded correctional system. So, because we have overcrowded our systems, the extension of probation to nonviolent, or from nonviolent to violent offenders, is a result. The conditions are set by the court. Some conditions are standard for every case, but other conditions not so much, and restrictions can be tailored to fit an individual's needs. Probation generally involves two parts. First, providing treatment and rehabilitative services of non-dangerous offenders who deserve a second chance, and second, to supervise and control offenders who might otherwise be incarcerated if probation wasn't possible. Some conditions: probationers are not allowed to leave the jurisdiction without permission, and specific instructions to enroll and complete rehabilitation or treatment programs are often a condition of probation. These are often tailored to the addresses of the offender's specific problems. Judges may not impose cruel or capricious rules in reference to probation, and as I've mentioned, probation may be revoked if a probationer fails to abide by these rules. There are some administration issues in reference to probation services. It depends on the state. It depends on the locality as well. And we see a majority combining both state and local with parole services. Probation officers often styles they're influenced by personal values and the department's general policies, and they often work in different ways. Some probationary officers work from a social worker approach, whereas others take the law enforcement approach. When we talk about the social worker approach, what we're talking about is they are there to assist probationers through the process and provide them access to appropriate services. The law enforcement side of it is it's just there to enforce the rules that were laid out by the court. They're not really concerned about the rehabilitation of the probationer. Some elements of probation. Well, the pre-sentence investigation. This is an investigation performed by a probation officer attached to a trial court after the conviction of the defendant. The intake is the process in which a probation officer settles cases at the initial appearance before the onset of the formal criminal proceedings. And it's where the process in which a juvenile is referred and received, and a decision is made to file a petition to the juvenile court. Diagnosis or risk classification is a more in-depth process whereby the offender is evaluated to determine the appropriate treatment mode. Supervision, of course, is a major part of probation. This is a general process whereby the probation officer decides how he will monitor the probationer's behavior. And then, of course, treatment is the probationary, is where probation staff carry out a therapy program to help clients deal with the problems that are suspected of being the cause of their antisocial behavior. If, for example, you keep getting DWIs, which create a social hindrance, maybe we run you through a alcohol rehabilitation facility. Some legal rights for probationers, of course, exist. We think about this in reference to civil rights and revocation rights. In reference to civil rights, the relationship between a probationer and a probation officer is not confidential. Therefore, anything a probationer tells a probation officer may be turned over to the police. This was decided in Minnesota versus Murphy in 1984. A probationer's home may be searched without a warrant because the probation department has in mind the welfare of the probationer and must respond quickly to the evidence of misconduct. This was decided in Griffin versus Wisconsin in 1987, and a probationer's home may be searched without a warrant for the purpose of collecting evidence of a crime if the search was based on a reasonable suspicion. This was decided in United States versus Knights in 2001. In reference to revocation rights, a violation of the terms of probation or committing a new offense can result in the revocation of probation, which in turn would place the probationer in prison or jail. Generally, the courts have required that probation officers adhere to due process during the revocation process. We also have to remember a probationer is entitled to counsel during the revocation process. This was decided in Mimpa versus Ray in 1967, and an informal inquiry must be held to determine whether there is a probable cause that a probationer has violated conditions of probation. This was decided in Morrissey versus Brewer in 1972. A judge may deny a probationer access to an attorney in revocation proceedings if the case does not result in revocation. This was decided in Gagnon versus Scarpelli in 73. The judge cannot revoke probation for failure to pay a fine or make restitution, which was decided in Bearden versus Georgia in 1983, and a revoked probationer cannot be given a longer sentence than the original suspended sentence, which was decided in the United States versus Granderson in 1994. You might ask yourself, well, how successful is probation? 60% successful. Most revocations are for technical violations within the first 3 months, and we're finding that it may be easier to treat offenders in the home environment, and of course it's cheaper for the state. How successful is felony probation? About 65% are rearrested, so not so successful. Probationers are still less likely to recidivate than felons sent to prison for similar crimes. So it is more successful than sending them to prison, but it still has issues. Probation is the most common form of alternative sentencing because, one, it's humane, two, it helps offenders maintain community and family ties, and three, it's more cost effective. Who typically fails on probation? Probationers with background or physical and sexual abuse tend to fail. Probationers who grew up with family members incarcerated for drugs tend to fail. And probationers with extensive criminal histories or prior incarcerations tend to fail as well. Who succeeds? Married probationers with children, people who have lived in the area for 2 or more years, people who are adequately employed probationers, and educated female probationers with stable marriages and employment. They tend to be successful. And what is the future of probation? Well, we see more and more of making probationers pay. Some states are now requiring probationer to pay fees to underwrite the cost of probation. Normally, these fees are based on the probationer's ability to pay. We see hotspot probations involving police officers, probation officers, neighborhoods, and social service representatives in a team approach for supervising the probationer. We see some focuses on area needs where some experts suggest that probation caseloads be organized around the areas of need rather than the client's needs. A move to specialized probation where some probation departments are experimenting with focused or specialized probation. And then, of course, private probations, where 10 states have contracted private companies to do the probation as well.